Welcome back, everyone. Today's courtroom chaos is the kind of footage that makes judges question their career choices and prosecutors silently reconsider law school tuition. We're diving headfirst into two absolutely unbelievable sovereign citizen cases, and trust me, these defendants are operating on an entirely different planet. And somehow, despite all of that insanity, Judge Simpson keeps his composure better than most people would.
Court cause case, People versus Joshua Wara.
Government vote for the people.
Mr. LeBeau's case. Wara.
Joshua. Thank you, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission
understand?
bar. I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay, but I've got to do something. I've got to do something with your case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue. And what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for 10 times the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion.
At this point, the courtroom has already completely left reality. The defendant isn't even attempting to respond to the actual charges anymore. He's just stacking conspiracy theories on top of random numbers and hoping something sticks. And notice something important here. The judge is still trying to keep the hearing focused on procedure. That's what experienced judges do. Even when someone is claiming they were robbed of trillions of dollars by secret Illuminati figures, the court still has to establish whether the defendant understands the charges and whether he's capable of representing himself.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount. But since it is conspiracy to murder, sovereign law
I'm with
does
you.
not
I got you. I just have to let you know what you're charged with.
I can sue for
There's
1,000
also
times the
count
amount.
2 on the complaint that alleges that on that same date and at that same time that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel,
No, I
then
do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen,
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any
on
point you
on
do,
objective
if
evidence. A
at
bench
any
trial
point
is
you
subjective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if
not
I can
exist
if I
because the
can
amount
interrupt.
of money that
I
they
don't know,
put
I've
that
not
they
been
got
very
on
good at
me,
it, but
and Donald Trump and Elon
oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates that and residencies in states that do apply the death penalty.
This right here is where things stop being funny and start becoming genuinely concerning. Sovereign citizen ideology often sounds ridiculous on the surface. Bizarre legal jargon, random constitutional references, claims about secret authority. But underneath it, there's frequently paranoia, delusion, and escalating hostility. The defendant is now connecting politicians, billionaires, judges, prosecutors, and random individuals into one giant murder conspiracy while casually discussing executions and death penalties. And unfortunately, courtrooms across America have seen this pattern before.
Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case.
Where I can't, again.
Okay, but you
There are
haven't
too
seen
many
the
people involved.
You
You have a
haven't
neural link
seen,
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's based on
listen,
factual evidence. The jury trial
I,
can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Warren.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peake, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
then.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir? I'm gonna
Yes.
give you your preliminary examination. So your preliminary
you.
examination will be set in person on,
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
no, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but,
with Carol
it-
Conkey in East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Wara and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's
That's a
today?
yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm gonna
And
do.
Donald Trump.
I don't know that we'll be able to go, given how you're
Yes, we
acting,
will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
You have to give the judge credit here, because somehow, despite everything we just witnessed, he still manages to keep the hearing moving forward professionally. Most people would be emotionally exhausted after being accused of working for Nazis, mind-controlled billionaires, and secret banking empires. But instead of turning the courtroom into a shouting match, the judge immediately pivots toward the real legal issue, competency. And honestly, that may end up becoming the most important part of this entire case. Courts have an obligation to determine whether a defendant actually understands the proceedings and can meaningfully assist in their own defense.
5T 5884. Entries from the people.
Ken G for the people, Your Honor.
And with that, good morning, or rather good afternoon now for the defense. State your first and last name for the record.
Robert Richards.
And with that, go ahead and have a seat. We're going to go ahead and do housekeeping. So we're here for motions and there's no resolution in this case?
No, Your Honor.
All right. And so with that, did you receive Mr. Richards' motion to dismiss the charges in this matter?
Yes, Your Honor.
And Mr. Richards, would you like to supplement the record by any oral arguments?
No, ma'am.
All right. And so for the people?
Your Honor, we would respectfully ask the court to deny this motion to dismiss. There is a factual basis for the charges as well as an unwillingness to unwillingness by Mr. Richards to come to a resolution in this case. So I believe that going to trial is appropriate resolution.
And so I just want to make sure I clearly heard you. This, you asked me to deny the motion because he's unwilling to resolve the matter?
We have not come to a resolution in this case.
Do you think that's a legal basis in which the court could do that?
And additionally, I believe there are enough facts to support the charges, Your Honor. And I believe that the people can prove this case with a reasonable certainty at trial.
And so as to Mr. Richards' motion, did you actually pull the cases he has cited?
I apologize, Your Honor.
As to Mr. Richards' motion, did you ever pull the cases that he has cited?
Yes, Your Honor. But we the people would argue that these cases are not pertinent to these charges.
Can you tell me why?
Under Flournoy v. First National Bank, Mr. Richards quoted, "If the state converts a right into a privilege, the citizen can ignore the license and..."
And this would be under which case?
He quotes Flournoy v. First National Bank of Shreveport. It's 197, California.
And before you go any further, because I did pull these cases, and one of them, the site's incorrect. All right, and you may continue as to Flournoy versus First National Bank of Shreveport.
He quotes that case saying, "If the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with immunity." I apologize, Your Honor. I believe that's Shuttlesworth v. City of Birmingham, 373 U.S. at 268.
Okay, because that's the case that I could not find.
I also could not find that case, Your Honor.
But you were able to locate it?
I was not able to locate that case, Your Honor.
I'm sorry?
I was not able to locate that case, Your Honor.
Okay, that's the incorrect site, and so...
Now this second case is a completely different flavor of sovereign citizen chaos. Unlike the first defendant, Robert Richards is calm, organized, and clearly believes he's presenting a serious constitutional argument. And honestly, that's what makes these cases so interesting. Because the confidence level is incredibly high, but the legal foundation is unbelievably weak. He's quoting constitutional amendments, citing Supreme Court cases, defining liberty, discussing jurisdiction, and to someone unfamiliar with the law, it might actually sound persuasive for a minute.
The United States are subject to jurisdiction therefore are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty or property without due process of law, nor deny any person within its jurisdiction equal protections under the law. Now I'd like to cite the definition of liberty: the freedom and exemption from extraneous control, the power of the will and its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from others. I apologize. The first amendment I read was Amendment 14, Section 1. Article 6, Clause 2, all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state contrary to the contrary withstanding. The senators and representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. The United States Code is the supreme law of the land. All states are required and bound by it. And the USC recognizes no law for a driver's license, for inspection, for insurance, or for registration. And the only law that they do have on the books is regarding registration for commercial vehicles. The word driver is a commercial term, which means that you're using the road for a commercial purpose or for a higher purpose. I have stated since I met with the officer who initially pulled me over that I'm a private traveler.
All right. Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not merely a privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in person but in safe conduct. And personal liberty consists of the power of locomotion to change situations or removing one's person to whatever place one's inclination may direct without imprisonment or restraint unless by due process of law.
This commentary absolutely destroys one of the most recycled sovereign citizen arguments on the internet. The so-called right to travel defense spreads online because it sounds intellectually sophisticated. People hear phrases like liberty, locomotion, and constitutional guarantees, and suddenly they think driver's licenses are optional. But there's a massive difference between the right to move freely between states and the claim that traffic laws no longer apply to you personally.
Vehicle registration law, regulation, or agreement that limits the operation in the United States of commercial motor vehicle. This is not registered under the state law if the vehicle is registered under state law participating in the plan. And that's USC 4931, subsection 31704.
All right, and thank you for that. And with that, the court will now rule as follows in this case. As to Mr. Richards' motion to dismiss, he has cited as his legal authority Murdoch versus Pennsylvania, which can be found at 319 U.S. 105. That's a United States Supreme Court case from 1943. And then we have Flournoy versus National Bank of Shreveport, which can be found at 3 Southern 2nd 244. That is a Supreme Court of Louisiana case from 1941. Both are still good case law. The court did try to find this Shuttlesworth versus City of Birmingham. The site is 373. I also looked at 375 US 260. That the case does not exist under that site. Okay. And as to each of these cases, we are here on this driving under restraint and an expired license plate charges. The first is a Class A traffic infraction. The second is a Class B traffic infraction, ineligible for a jury trial, but a court trial. And as to Flournoy versus the First National Bank of Shreveport, the actual issue in that case is that they did challenge, and that would be Flournoy challenged a statute that was limiting in value bank shares for taxation. The court found that that was unconstitutional. It has no bearing on a driving under restraint or a license plate being expired. And then in Murdoch versus Commonwealth of Pennsylvania, what was happening there is that the city of Jeanette, and it was an ordinance by the city of Jeanette in Pennsylvania, was prohibiting the sale of goods, wares, and merchandise of any kind within the city by canvassing for or soliciting without a license. And the United States Supreme Court found that that was in violation of the Constitution, the United States Constitution, freedom of speech that is guaranteed by that First Amendment, because it was preventing people that had religious beliefs or were on the streets just preaching the gospel from distributing religious literature and then having personal visitations with individuals as they walk by. And they found that that requirement prohibiting any sale of goods, ware, or merchandise of any kind without a license was in violation of the First Amendment. And so as to all that has been cited by Mr. Richards, I appreciate it, but we do have laws here in the state of Colorado that do require you to have a driver's license and that privilege, and also have your vehicle license. And so as your motion to dismiss the charges in this case, that housekeeping. So have you gotten down to the district attorney's office and received your discovery in this case? No. All right, you will need to have your discovery because the people are indicated they have 2 audio files and 3 video files for a total of 5 media files that they may be using in a trial. You will need to be able to review those because I'm going to set some deadlines because I need the parties to confer about what will be coming in and what will not be coming in. And it'll be extremely beneficial if you know exactly what that is. And so during housekeeping, what I do is I go back to the date and time that a case was filed with the court. And I review all motions or notices that could potentially affect trial in this matter. And since the not guilty plea was entered and the JASP order went into effect, the people found 1 notice of endorsement of witnesses on just September 12th of this year. Did you receive a copy of that? And could you approach? Here's all I'm going to give you a hand delivered to your copy. These are all the people that they possibly or potentially could call, and that's for you. You can keep that. That's yours. Wow. Oh, that's who they're going to call or potentially call. That's their potential witness list.
So the officers that were there on scene?
Yes.
There were 3 officers, not 4.
And they're saying there's 4. So
I saw 3.
And so that's who they're intending. They could potentially, I'll make it tell you that they will actually call those 4 officers. or whoever the 4 witnesses are listed, because I didn't look at it that closely. But that's who they're intending or potentially could use as witnesses in this case. If you want to know how those individuals are related to this case, that's where the discovery comes in, because there should be reports from those individuals, or some type of statements, or some type of mention of those individuals in somebody else's reports. That discovery will tell you exactly who those people are, hopefully, and then also we have all these audio and video files. So with that, would you like to go down and get your discovery? In this case, it's free.
Yeah.
All right. So could you give them your address to your office? And you need to just go to, I think the fastest way is to go down there. Is it the fastest way to go down there and get it? Or does he do it online, or?
He has to request it online first, and we have to process it for him to be able
So what happens if he goes down to your office?
This is probably the most important moment in the entire hearing, because the judge explains exactly why sovereign citizen arguments consistently fail in court. It's not because judges are hiding the truth or refusing to hear constitutional argument. It's because the cases being cited simply do not apply to the facts at hand. And that distinction matters enormously in law. The judge methodically walks through every citation, explains the actual historical context, and shows how none of them eliminate Colorado's authority to require a valid driver's license and vehicle registration.
These are valid charges that the state of Colorado has the authority to actually enact these types of statutes.
Okay.
Okay. And so with that, for the people, did you file any additional motions or notices that the court is not aware of?
No, Your Honor.
And there were none other than the motion to dismiss filed by you, Mr. Richards, is that correct?
Yep.
Okay. So again, the people have 2 audio files and 3 video files for a total of 5 media files. And with that, the court will now issue the following orders. As to those 5 media files, the parties are to conclude their conferral as to which portions or which portions will or will not be used of those 5 media files by this next deadline. Also, if there's any additional witness endorsements or initial witness endorsements, they must be filed by this deadline. And if any party wishes to use an expert, that expert must be disclosed by that same deadline, along with the CV for the expert. And Mr. Richards, you know what a CV is, correct?
No.
Okay, CV is the equivalent of a resume for an expert. It actually stands for curriculum vitae, CB, curriculum vitae. And all this is basically a resume for the expert to say why they're expert, what type of training experience, classes they've attended, those that they've actually taught at themselves, recognitions within that industry. And also pursuant to Rule 16, I'm going to order that a summary of the expert be provided. In other words, tell the opposing party what the expert will be testifying to. So again, the parties are to confer as to these 5 media files of what will and will not be used by this deadline, conclude that conferral. Also, any additional or initial witness endorsements, if you're going to include anyone as an expert, you must designate at that point in time in writing that the person is going to be an expert. Tender over to the opposing party the CV for that expert, and also a summary under Rule 16 of what that expert will be testifying to. That must be done by Friday, October 3rd. That if there are any objections to any redactions to that media or lack thereof, that objection must be in writing and it must be supported by a legal basis.
So if I just want to pay the fines now, you're obviously not going to side with me in this. So if I just want to pay the fines and walk away from it.
Not either siding with or for against anyone. I just follow the laws here in the state of Colorado.
My right to liberty is invalid. So if I just want to pay the fines and walk away from this, what?
No, you have rights and you have liberties, but also here in the state of Colorado, these are valid charges.
Not in the state of Colorado. I'm a man standing on land. I am not a dead entity inside of a state.
Okay. Would you like to enter into a plea agreement then with the people?
What are we looking at for fines?
Well, can we pass, Your Honor, while
You may.
discussing?
This particular instance,
You still would,
I would.
if you would like to see
So I
what
need
the
to-
discovery is and if you want to object to anything.
All right.
So there's some additional deadlines. And so we are back on the record on Robert Richards, case number 25T5884. He is present before the court, and so is Ms. G for the people. And so if there are any objections to any redactions or lack thereof of those media files, In other words, people are going to use something that you don't think they should be able to use, or they're not going to use something that you believe that should be used. You must state that in writing, and you must support it by a legal basis. In other words, you just can't say I object. I have to know why you're objecting under the law. And you must tender to the court the media in question by that next Friday, which would be October 10th. Now, failure to, even though you may have submitted a written objection that's supported by a legal basis, if I do not also receive the media in question by that next Friday, October 10th, then the court will deem the objection to be abandoned. And the reason why is this: I don't have access to their discovery. And so I don't have the media files. I have to be able to have the media file to review it, to be able to rule on it. Now, within that same written objection, the opposing party, you may respond to that objection with your own legal basis. But if you fail to respond, the court could deem your refusal or failure to respond as a confession of that objection. And I could grant that objection as written. But irrespective of if there is a response or not, if a written objection is found supported by a legal basis.
And there you have it. Two completely different sovereign citizen court appearances, both ending exactly the same way. Reality colliding headfirst with fantasy legal theories. In the first case, the courtroom descended into absolute chaos with conspiracy claims involving billionaires, secret organizations, death penalties, and imaginary financial empires. In the second case, the defendant tried a calmer, more constitutional strategy, but the result was identical once the judge actually examined the law and the cited cases.